So, all right. Hi, everyone. Welcome to our session tonight. My name is Titilola, and I'll be taking you through topic 2 of the Foundations of Canadian Law syllabus. And this is in preparation for the April 2026 exam. So we'll get right to it. And the materials that I'll be teaching from is also available on the website. If for any reason you can't access it, please reach out to me or to Mr. Ammar. So tonight we're going to talk about the first part. So the way the syllabus is, you have 3 or 4 sections. So you have section A, which I like to think of as the historical. So tonight we're dealing with the historical part, what happened before now. And then gradually we move to where we are and where we think we might be going. Then tomorrow we'll begin to look at some articles and cases. The articles are very important, and you usually will get questions from the articles or from the cases. So we'll go over every one of the articles. We'll go over as many of the cases as possible as well, so that we're really well grounded in this area. There are no guarantees that you'll get a question or that you won't get a question from Aboriginals. So we will do our very best to make sure that we're very, very well prepared. So let's get started. So when we say Aboriginals, indigenous people, what comes to mind? What's the first word that comes to mind? Just a word.
Native.
Native. Okay, good. Anyone else?
Original inhabitants.
Sorry, I didn't hear that.
Original inhabitants.
Original inhabitants. Okay, fantastic. Yes, thank you. Anybody else? So you're both right. Original, inhabitant, native. Those are things that come to our mind when we think about, the Aboriginal people of Canada. And I like to always make the point that Aboriginal people are not only in Canada. There are other parts of the world where you have people who are indigenous to that particular geographical area. So, but because we're talking about, what has happened with indigenous people within the Canadian context, that will be the scope of our conversation. But there are many indigenous people in different parts of the world. So right off the bat from our syllabus, they have asked us to read chapter 3 of Bryden, and we'll go over some of the notes there. And then we have section 91, sub 24 of the 1867 Constitution. So for those who have written constitutional law, you're very familiar with this. And where do we, under constitutional law, what topic do we find section 91?
Division of power.
DOP, division of power, you're right. Yes. So section 91 and 92, that's when we talk about section 91, talks about the powers that the federal parliament has. And then section 92 talks about the provincial legislature, what powers they have. And then we talk about, various concepts or principles that have developed into jurisdictional immunity, double aspects, but those are not our concern. For tonight, our concern is section 91(24), which says that anything related to Indians and lands reserved for Indians, falls under the exclusive jurisdiction of the federal parliament, meaning that anything pertaining to Indians is the federal government, is the federal parliament that has, the power to make any legislation in that area. Now, does it mean that Indians or indigenous people do not have to comply with provincial laws? No, it does not mean that. But it means that any law that would touch on the Indianness of an Aboriginal person, only the federal parliament can make laws about it. And this is something we'll come back to in one of the cases that we're going to review subsequently. Then we also have section 35 of the 1982 Constitution. So question, for those who have written constitutional law or who have not written constitutional law, is section 35 part of the charter? Is section 35 part of the Charter of Canadian Rights and Freedoms?
I think so, yes.
Okay. Amina, you
So
think it is?
this is Purnima, but I'm not.
Anybody else want to take a stab? Thank you.
I
Anybody
said,
else thinks
no, it's not part of the Constitution.
it is not
It's
part of
part of the Charter, sorry.
it's not I was going to say it is part of the Constitution, but it's not part of the Charter. It actually sits outside of the Charter. And so that's another thing to keep in mind. So that because again, when we consider some articles where we'll talk about the tension between charter rights and in an Aboriginal right and title, we would see where that tension comes in. And then we won't go a lot into, like Section 33, the notwithstanding clause. We won't talk about Section 1, Oakes test, because again, those are beyond the scope of what we want to cover in foundations. But I just need you to have it at the top or at the back of your mind that Section 35 sits outside of the Charter of Rights and Freedoms. So it is not a part of the Charter. So because it's not a part of the Charter, that means Section 1 is not applicable to it. So it's a different conversation. When the government infringes on Aboriginal rights and title, it's a different conversation for how government justifies. That's when we talk about Sparrow test. That's when we talk about Degamo. Again, we'll come to all of those cases tomorrow or next week. So Section 35 codifies and says existing Aboriginal and treaty rights of Aboriginal peoples of Canada are recognized and affirmed. And the cases we'll consider would walk us through how the courts have interpreted this from, I think the first case that dealt with this according to our syllabus was Sparrow. I would see how the courts have, over a period of time, from like 1990, how they've interpreted, and applied Section 35 when we're talking about Aboriginal title and Aboriginal rights. So, and then it goes on to say that when we talk about land claims, it includes the land claims agreements that are already, entered into with various indigenous groups, and the ones that may be acquired, including the ones that may be entered into. Some of the articles I will share with us is about some more recent land claim agreements that have been entered into with some indigenous communities and the government, giving them some self-government. Again, we'll come to the inherent right of self-government. That's not for today. I think we'll get to that tomorrow. So all of this is to lay the foundation. Like I said, tonight is historical, what happened in the past, how have things evolved, and then where are we now, and then how do we chart the course forward. That's our objective for tonight. So, of course, you were both right. Excuse me. Okay, so when I asked, they said, when you hear Aboriginal, what comes to mind? And you said native, original occupant. And that is very correct. When we talk about the indigenous people of Canada, we're talking about the initial occupants, the people who were native to the geographical area that is now known as Canada. And if we go back a bit, I will share the links to the Canadian Encyclopedia, which gives us, some background about what happened, how the relationship evolved. So what had happened was before European settlers came into this area that is now known as Canada, there were various indigenous groups that were living here, and they had their own form of government, they had their legal systems, they had their cultures, they had their practices, they had their languages. They were not a homogeneous group. They were not like all one and the same. No, they were distinct groups, distinct tribes with distinct practices. And initially it was the French who came. Who is iPhone? Okay, I'll admit this person, but I need to know who it is. Okay, so initially it was the French who came, and they came on the basis of trade. And when you watch that documentary that I saw, Canada, the Story of Us, it gives, that historical background of how they came because of fur, and how, from various animals they were able to get quality for until they discovered that the beaver had really, really good quality for. And the people who were really into that business were the indigenous people in various parts of Canada. And so they started having trading expeditions come to this part of the world. And in time, it became a case of, oh, it takes so long to travel back and forth. Or let's give you a place, you can stay here. And so the relationship grew on the basis of trust, on the basis of friendship, on the basis of peace. In time, there started to be the desire for, to own something, to have something. And then of course there were wars in different parts of the world, countries wanting to claim or to make their claim on particular areas. And so there was war between, the European settlers, the British and the French. And the British, persuaded the indigenous communities, like, fight for us, don't fight for the French, who will treat you well, will be good to you. And so a lot of treaties were entered into. And we'll see some of those treaties. And we'll see how, at the time they were entered into, what was the thinking and how the courts now interpret them. So now we have historical treaties, which are the ones that were entered into, in the 1700s, 1800s, how the court interpreted them over a period of time, and then what is now happening with historical treaties and modern treaties. But again, let's not get ahead of ourselves. So it was widely understood that, oh yes, at the time when the settlers were coming in, it was understood and agreed that they had their systems. But over a period of time, the thinking started to change. There were different thinking across Europe about one culture, one tribe, or one race being superior to the other. And with all of this happening, it began to cascade and translate into the relationship that the indigenous people had with, settlers who were here. And so during the period from early 1900s to the 1970s, the sentiment changed and it became a case of, oh, we don't think they had a system before we came. They were savages. They didn't know how to organize themselves. And you have to ask, but you were doing business with them. So if they didn't know how to organize themselves, how were you able to do business with them for so long that you even started to desire to live where they were living, to have access to the resources they had? And you were able to enter into agreements that made the railway possible, which connected different parts of Canada. So again, as sentiments changed, the relationship started to, fall apart. And before, just to backtrack a bit, so early Canadian states, what happened before 1982, the relationship was nation to nation, right? So settlers came, they met different nations, and they started to relate with them. Started to relate with them nation to nation. And there was that understanding. And a lot of peace and friendship treaties were entered into. Even also at that time, when the Royal Proclamation, I think it was around 1867 as well, that the Royal Proclamation was made, there was that understanding that the indigenous people had rights and privileges that belonged to them. And so in some cases, they gave land to the settlers and said, we're giving you this land, maybe exchange of some sort of goods, some trade by barter. And in some cases, they were like, we're giving you the right to use it. We're not giving up our right to it. So those things worked for a considerable period of time. And as long as that relationship remained like that, there was a lot of progress that was made. There was respect on both sides of the divide. The indigenous systems were respected. And there's the case of Connolly and Woolwich, where an English court held that the marriage between an indigenous woman and a non-indigenous man under Cree law was valid for the purpose of inheritance. So at this time, there was that understanding that yes, they have their own systems. They had inheritance systems, they had family law systems, and those systems worked. And so it wasn't like, oh, these people have no idea how to organize themselves. So it was really okay and nice. And then we moved to the second period, which is when we now had the influx of the British, which led to a decline of indigenous populations. And there are many stories or many some of the information that is available is that in time, as the settler population increased,